Good afternoon, and thank you for coming to a presentation on the Fair Labor Standards Act exemption basics. My name is Bob Hendler. I'm the Classification and Pay Claims Program Manager for the U.S. Office of Personnel Management. And what that means in relationship to what we're doing today is that my program deals with Fair Labor Standards Act claims filed by certain federal employees. And the first thing that you do in dealing with the FLSA is to determine whether you're covered by certain aspects of the FLSA. Just to kick off today's session, this really is a session dealing with basic principles, practices, and concepts. And we do have the opportunity to deal with questions, and as a matter of fact, it would probably be best if those questions came in while we're covering the specific topic at hand. That way I can tailor the presentation better to the audience and what the audience's needs are. But this session really is not meant to deal with individual case issues. Those are things that require much more detailed discussion than what we can do here today. And those are the kinds of things that you can certainly email me or call me about after the session, and I will try my best to get back to you in as timely a fashion as I can. That being said, let me start off with a little question to the studio audience in here. By a show of hands, how many people in here think that they are covered by the FLSA? That's a trick question. You're all covered by the FLSA, and I'm introducing you to how complex the terminology is under the Act. It's just that most of us, certainly I, am not covered by the overtime and minimum wage provisions of the Act. And that makes my work and me non-exempt. But the bottom line is the FLSA applies to, in general, federal employees. So that's something to think of in terms of just how complex the terminology is and how you need to sort of go back every time you have to deal with an FLSA issue, go back to the basics of dealing with it. Now, there are two primary organizations that administer the FLSA in the United States. And I like to describe OPM as sort of the tail of the dog in terms of managing or administering the FLSA, because we only cover certain federal agencies. The Department of Labor is responsible for private sector, including nonprofit, state and local government employees, and certain employees in various federal agencies, specifically when you go into our regulations, and it's based on the law, the statute itself, the Postal Service, Postal Rate Commission, Tennessee Valley Authority, Library of Congress. There's a third entity that has a relatively small number of people, and that is the Office of Compliance, that deals with legislative branch employees. So one of the questions would be, if you are in a particular kind of agency, let's say you work for the Capitol Police, U.S. Capitol Police, you're going to fall under Congress's Office of Compliance, and you won't fall under OPM. And it's a very confusing thing because we routinely get correspondence from Postal Service employees, and we have to explain to them we don't have jurisdiction over their issues. One of the other things, too, is that the Fair Labor Standards Act has been interpreted by the courts as providing OPM with certain flexibilities in administering the Act, because we have other laws with which we have to harmonize our application of the FLSA. So, for example, and there are court cases that we cited in our regulations, you could make an argument that because we're all accountable to the public for each and every hour that we work, we have to account for that work by either taking leave with pay or without pay in order to account for the typical 40 hours a week, 80 hours a pay period, and we won't get into compressed or flexible work schedules at this point, which is another thing. One would say that only those people whose pay is not docked if they don't show up to work would fall under the exemptions of the FLSA. That's not how it applies to the government, because there are other statutes in place that we have to harmonize the FLSA with in order to deal with hours of work. I wanted to lay that out for you because there are a lot of other differences in how the FLSA is applied in the federal sector as opposed to the private sector. Before 2007, the last time the FLSA regulations issued by OPM were substantially changed was 1997. I guess maybe we'll get into a practice of doing it every 10 years or so, whether we need to or not. But the reason why we revised the regulations very substantially in 2007 is that Department of Labor issued new regulations, the first major changes in regulations in about 30 years, in 2004. So we went through a very lengthy analysis and regulation writing process to update our regulations. And what we took the opportunity to do was to clarify issues specific to the federal government. One of the things that you will find in the 2007 regs that went into effect October 17th of 2007 are examples, specific examples of federal work situations to illustrate how we believe the exemption criteria of the Act are supposed to be applied. And we'll get into that a little bit later in more detail. One of the key things in the FLSA is to have an understanding of the definitions and the coverage. So you need to be aware of the fact that you may get into situations where the first thing that you need to do is to figure out whether that person is an employee for purposes of the FLSA. And let me give you an example. How many in here are familiar with Department of Defense field installations? Like installations that have exchanges. Okay, very good. Frequently, or at least in the past number of years, it's not unusual for a military installation to contract out certain services that are made available to the military at a base. For example, a barber shop, a hair salon, florist shop. They're not employees. They are independent contractors. And that's important because that determines their status for purposes of the application of the FLSA. And that's why you need to go to Section 2105 of Title V to determine whether they are an employee for OPM's purposes for application of the FLSA. And notice, as a civilian in an executive agency is defined elsewhere in the statute. So this is putting the pieces of the puzzle together, if you will, in determining whether this is an employee covered under OPM's FLSA regulations. As a civilian in a military department, believe it or not, we've gotten letters from military members, people in uniform, complaining about not getting overtime pay. And we have to write back to them and say, you're not covered by the overtime provisions of the FLSA. In a non-appropriated fund instrumentality, aka NAFI, people in here familiar with that? That's something that I was speaking about before, when you have the officers club, the enlisted club, those kinds of activities at an Army, Navy, or Air Force installation. They are supposed to be self-supporting. The people who are employed there are not competitive service employees for the most part. So if you're, and there are, a couple of other agencies that have non-appropriated fund organizations located on their installations at their sites. For purposes of the FLSA, OPM was specifically given jurisdiction over them. And you'll find that, by the way, in Section 2105 of 5 U.S.C. In a unit of the judicial branch of the government that has positions in the competitive service, I've been around government for almost 36 years, and I haven't seen one of them yet. But I may before the end of my career. One never knows. But I think they're a pretty rare bird. And one of the things that we would have to consider were we in that situation is really, the first part of it would be jurisdictional and in the government printing office. I know that the Act went into effect probably before anyone in this room was ever born, and certainly actually before I was born, contrary to popular belief. But it was not extended to the federal service until 1974, when it was also extended to state and local government. Carter v. Gibbs and Mudge v. U.S. would mean quite a bit to you probably if you were in the labor relations arena of human resources. What both of those cases represent really is a sea change in how we deal with claims under the FLSA. Prior to 1990, OPM accepted federal civilian employee FLSA claims under our jurisdiction to administer the FLSA. We had in what was formerly known as the Federal Personnel Manual a specific FPM, I believe it was a letter, 551-9, that provided for employees to challenge their FLSA coverage status by filing a claim with OPM. In 1990, the federal courts found that the certain sections of the Civil Service Reform Act essentially, in my personal opinion, excluded about 90% of the claims that we used to deal with from OPM's jurisdiction. And what do I mean by that? What Congress said was, if you're in a bargaining unit position and there is a contract, and the contract has a negotiated grievance procedure, unless that negotiated grievance procedure specifically excluded FLSA issues from the scope of the negotiated grievance procedure known as the NGP, they were automatically included. Actually, that's the Mudge. Prior to that, what Carter v. Gibbs dealt with was a court saying that because of the way the Civil Service Reform Act was written, those employees only had an administrative process to follow. They declined to grant judicial review. That was changed by Mudge because there was a change in statute after Carter v. Gibbs saying that the Civil Service Reform Act limited it to the sole administrative remedy. So in other words, the NGP is an administrative remedy, and it returned federal employees' ability to seek redress before a court of law. Remember, there are two separate procedures here. A statutory procedure before the third component of the federal system, the federal courts, as opposed to an administrative process which requires about a 44-cent stamp, has no filing fees, and allows an employee primarily and usually to represent themselves, asking for a review of the agency's decision on their FLSA coverage. In 1994, another very important change to FLSA in the federal sector. Prior to 94, the former General Accounting Office, now the Government Accountability Office, dealt with FLSA pay claims as opposed to coverage claims under the Act. And GAO had applied a 6-year statute of limitations based on their reading of the Barring Act. In 1994, GAO reversed itself and said, whoops, we made a boo-boo. The FLSA itself has its own statute of limitations. 2 years, 3 years if the violation was willful. Congress stepped into the situation, but the bottom line is today the statute of limitations is 2 years, 3 years if willful. So those are major FLSA moments, and they affect how we have dealt with cases and how we deal with people under the FLSA. When you read the definitions here, I think you will find them to be what I kindly describe as counterintuitive. So when you read someone is exempt, that means they're not covered by the minimum wage and overtime provisions of the Act. Or non-exempt, meaning they're covered, it seems to reverse what one would think is the natural use of the English language. So be it. It's been that way since 1938, and I don't think we're changing it anytime soon. But the other thing, too, that I want to point out is exemption status is an employee's designation. Now, for those of you in the Human Resources Office, I'm going to throw out a question, or Human Resources occupations in here. What do we usually look at when we make an FLSA determination? Position description. Well, that's the initial step in the process. But, as I'll go into a little bit more detail later, ultimately it's the work actually performed by the individual. I like to say that the exemption status determination for the PD is the initial step in the process. And certainly if you've analyzed the work properly and the person is actually doing that work, then the FLSA designation is going to be correct. But ultimately, it's the actual work performed that controls the FLSA designation. Primary duty. One other point I want to make right up front here. We're using a lot of terminology that is also used in the position classification process. But as we discussed in our final regulations in the Federal Register, the terminology may be similar, but the law and its intent are different. And you're going to say, well, what do you mean by that? What we evaluate for purposes of classification is the differences in the difficulty, responsibility, and qualification requirements of the work performed. In other words, what is the complexity and difficulty of the work? FLSA classification considers things that are not directly related to making a classification determination. And I'll get into that a little bit more later. These are also the basic underlying principles of determining whether an employee is exempt or non-exempt. And that is, each employee is presumed to be exempt. If there's reasonable doubt, non-exempt. Would anyone like to hazard a guess as to why the Act is structured that way? Don't all raise your hands at once. The bottom line here is, remember when the Act was passed. Go back in your history. It was the Great Depression. This is an Employee Protection Act. It was to protect employees from literally being worked to death and being paid no overtime pay and working 60, 70 hours a week. If you look at the statement of Congress's intent, which is the first section of the Act, it is essentially to protect the American workforce. By the way, there was also another impact on the workforce in that it really got industry to think in terms of, do I really want to pay someone the equivalent of 80 hours of pay for 60 hours of work if the last 20 hours have to be overtime? Or do I want to consider establishing another half-time or eventually full-time position and just pay regular straight pay so that I don't have to pay time and a half pay, if you will? So it was an incentive to increase the number of jobs available during a period of incredibly catastrophic unemployment. One change that we did make in the regulations to make it crystal clear that you can't just ignore looking at the person's work and just presume that the person is non-exempt. We require you to look at the exemption criteria and apply them to each and every employee's work. Because if you're an exempt employee, you should not receive federal money as if you were covered by the FLSA overtime. Your entitlement to overtime, likely, certainly for everyone in this room, is going to be Title V overtime. But there are other overtime laws out there that cover other federal employees. So it's inappropriate, for example, to give FLSA overtime to, let's say, an attorney. And we'll learn later that attorneys who do real attorney work are professionally exempt from the FLSA. The third bullet there is really very, very important because I've actually seen mistakes made. I actually saw a case where an agency decided to pay professional engineers FLSA overtime. For the fourth bullet, narrowly construed means that you don't take, it's the opposite of what OPM did back in the 70s when we took a very expansive view of the administrative exemption, which ended up in numerous court cases and had OPM rethink its approach to the administrative exemption in the 97 regulations and certainly even more so in the 2000 regulations. It all goes back to the second bullet, if you will, here, If there's reasonable doubt as to whether the person is exempt, you non-exempt them. The benefit of the doubt is given to the employee. There's a presumption of non-exemption. The burden of proof rests with the agency. Once again, it's an Employee Protection Act. So it's not that the employee has to prove that they're non-exempt. It's that management, agency management, has to clearly show how they meet one or more of the exemption criteria. The last bullet will probably give you pause in terms of it seems kind of complicated. And that's for someone who, let's say they're a supervisory paralegal. Paralegals typically are non-exempt because they are not doing what is considered to be legal work requiring entry and membership, passing the bar exam and entry into the bar. But even though they may be non-exempt in terms of the professional exemption, if they are doing the supervisory functions that would make them exempt under the executive exemption, then they can be exempt. You can also have positions that are what I call double exempt. Supervisory engineer, supervisory attorney, supervisory accountant. Once again, they're probably professionally exempt and they meet the executive exemption. Stop for a second and see if anyone has any questions at this point. Yeah, I know the verbiage is rather dense, to say the least. Non-exemption of certain employees. You'll find in our discussion in the regulations that there's something of a confusion, as I said before, with classification. There can be some very, very high-graded positions out there that are doing their work that is highly complex, requires a great deal of knowledge, demanding application of guidelines, great complexity. But just because it's difficult and complex work for classification purposes doesn't necessarily make it potentially exempt for FLSA purposes. And one of the examples, and for those who are not familiar with it, but when FAA air traffic controllers were covered under the classification system, there were lots and lots of non-supervisory 14s out there based on the air traffic control classification standard. And if they are in operational positions in an air traffic control tower, an en route center, whatever, they're non-exempt. GS-14 and non-exempt. And that's why I keep on going back to the fact that we're looking at two different ways of evaluating work under the FLSA and under our classification systems. The last phrase in there, unless such employees are performing predominantly administrative functions rather than the technical work of the occupation, let's say you have an air traffic controller working in the policy organization for FAA, developing FAA's policy on certain programs and practices. As we'll see later, that may well be administratively exempt. So you're looking, that's another very important thing. You have to look at the actual work being performed and the situation to determine the exemption status. Essentially, blue-collar employees are non-exempt. The sole exception there will be supervisory tradespeople if they meet the executive exemption criteria. That makes life pretty easy in certain organizations in terms of making FLSA determinations. recognized organizational unit with a continuing function. Well, we have a discussion of what constitutes a recognized organizational unit in the regs. But let me give you an example of a court case that, shall we say, gave a federal agency a great deal of agita. People familiar with the census? Little thing that's going on right now? Well, census has, or had in the, I guess it was the 2000 census, FOSs, Field Operations Supervisors. They were sort of the first level supervisor out in the field, honchoing the work of census workers. And they sort of floated from place to place. And clusters of people reported to them for a short period of time, and then they moved and other workers reported to them. And the bottom line was this went to court. And the court found that the FOSs did not supervise any recognized organizational unit with a continuing function. Now, of course, the court case went into much greater detail in terms of other things that they lacked vis-a-vis meeting the executive exemption, which we'll get into later. But the bottom line is that this has occurred in other agencies as well, where you have sort of these amorphous, non-specific and non-official teams. The primary duty test, once again, the definitions in 551-104 are extremely important. But the bottom line here is that not every supervisory position will be exempt. For those of you who are familiar with the General Schedule Supervisory Guide, if you took a look at certain, I think it's level 32A in particular, and if you looked at the delegations of supervisory authority there and matched it to the specific words in the executive exemption, you'd be scratching your head to figure out whether that supervisor with those limited authorities would be FLSA exempt, and in all likelihood they would not. And that's a point I've made, because once again you can't transfer from the classification process to the FLSA process unless you want to take a real big risk.
Question? Does that apply to lead workers?
The question here is, does that apply to lead workers? Lead workers, by their very definition, don't have the supervisory authorities that you'd be looking for in the executive exemption. There may be some lead workers who might meet the administrative exemption as we've described it in 551.206, and I think the section is I. But once again, be very careful, because quite clearly, and once again, we do have some linkage between classification. If you have a lead over single grade interval work, as we have it in our classification system, no way, no how are you going to be exempt. And if you make that person exempt, you're probably going to have to pay out money somewhere down the line. Now, this gets me to probably the most difficult concept to wrap your minds around when it comes to the FLSA. It's an Employee Protection Act. People, think back, well, for some of you, when you were reading your history books in school, thinking back to what America was like during the Depression in 1938, it was primarily an agrarian and an industrial society. So you were looking at a manufacturing economy. Huge numbers of people would be on the factory floor, and you would have this small group of people hanging out above in the factory floor in the offices, actually managing the enterprise. The administrative exemption is different from the executive exemption, if you will, and when you read the specifics of the reg, you have to supervise 2 or more FTE to ever possibly meet the executive exemption. There is no such requirement under the administrative exemption. The administrative exemption covers people who are assisting the executives, if you will, manage the enterprise. Now, I know it may be hard to believe, but in a factory back in 1938, it wouldn't be surprising to have a director of human resources solo, no subordinates. They were part of the management structure, but they would never meet the executive exemption. Yet they were key to managing the enterprise. The head of finance, who, on Thursday, if the quarter was finally closed out, and who didn't have to account for hours of work, could go out and play golf, go hunting, or, whatever, knit. That person might only have one person reporting to them, like a financial assistant. They would not be covered by the executive exemption. Yet they would be integral to helping to manage the enterprise. And that is why the administrative exemption exists. This is, if you will, staff work. Or what we will get into that a little bit more later. And also, look at midway down, or the employer or the employer's customers. So remember that there are some staff organizations that exist that are inherently staff. You could argue that the line work of OPM, for example, is HR. And since HR is line, that's not staff work, so it's non-exempt. But that's not it. HR is an inherently staff function. We function like a management consultant firm, if you will, in some ways, in that our customers, our clients, are the other agencies to whom we issue policies, regulations, and the like, and who we help understand and implement those policies and regulations. Those of you who are familiar with the Defense Information Systems Agency, DISA, or the Defense Finance and Accounting Service, those are agencies that have been carved out of the DoD services and Fourth Estate, as we call them, and made management agencies. It doesn't change the inherent nature and function of that work from staff work to production work, if you will. And that's a very, very important concept to wrap your mind around. So that OPM's, for example, OPM's HR office is a staff office to helping OPM management manage the enterprise, meaning OPM. But in terms of looking at where OPM itself fits into the FLSA construct, you're looking at OPM being a staff agency. I would compare that, for example, to GAO, which is a staff agency to Congress. So those are very, very important things. And one of the other things that we need to get into here is discretion and independent judgment with respect to matters of significance. This is something that the courts have had a very interesting time in applying over the last, I guess, 70 years or so. It's been a constantly evolving thing. And let me give you an example. OPM, in dealing with FLSA claims, it's not unusual for us to, and we have handled in the last several years, a number of construction representative claims. These are people who go out and review work performed on dams, bridges, putting up federal buildings, so on and so forth, done by contract firms. They're essentially the contracting office's eyes and ears on site, making technical determinations as to whether the contract specs are being met. But for the most part, every single one that we've dealt with in the last, I'd say, 10 years, whether they're, and typically they're at the 11 and some are at the GS-12 level, they've had a grand total of authority in terms of monetary significance of about $5,000 for a change order. Anything other than stopping construction for literally safety of life, life and limb, is sent to the construction superintendent or supervisory engineer or whatever. So even though they're doing highly demanding, complex work, let's say appropriately classified for sake of this exercise, at the 11 level, you can't say that that circumscribed area of authority represents discretion and independent judgment on matters of significance. You may well find that in an organization that does budgeting work, that you have reasonably complex budget work, let's say at the 11 level. But that person is doing that complex work and making their own decisions on their own work. That's not what discretion and independent judgment on matters of significance means. What it is matters of significance to the enterprise and its mission. That's to contrast that person with, let's say, the primary or lead budget person for an executive office developing a weapons platform, where they're spending their time looking at long-range planning issues, long-range budgeting issues, working out various scenarios and laying out not only what the alternatives are, but let's say proposing what they recommend as the best alternative, the best course of action. That, I would posit, would reflect discretion and independent judgment on matters of significance. So just as there's purchasing work, and there's purchasing work, there's budget, and there's budget. So let's not forget, in the federal system, there are budgets that are simple and straightforward enough to be done by budget technicians, and others that require sort of what I'd call mid-level budget analysis, and others that really do deal with the issues of matters of significance. You'll see in our discussion in 206 that if someone is doing rather rote HR work, if you will, in the back room, primarily tweaking crediting plans, applying them, doing the rating and ranking, and setting up the cert, that's not discretion and independent judgment on matters of significance. if that person is doing that work in conjunction with sitting down with management, providing advisory services on recruitment methodologies, potential sources, what's worked in the past, what hasn't, even if it didn't work in the past, have the circumstances changed enough to potentially use this or tweak it and try a slightly different approach to the same thing, that probably would be the exercise of discretion and independent judgment on matters of significance. So it's one of the things you may want to look at is that even if, let's say, your full performance level work is clearly exempt, probably positions in the career path below that level, most if not all of them will be non-exempt. Also notice I don't use trainee. That's another problem. Trainee has a different definition for FLSA purposes than it does for our federal staffing purposes or classification purposes. So I don't want to sound too persnickety, but when you start mixing and matching, you can get into trouble. As you can see, we've already gone over a good chunk of this. The non-manual work test, that's one of those really, bizarre kinds of things. Office and non-manual, you've got some problems there in that not every bit of manual work somehow you wave a magic wand and the work becomes non-exempt. Even though it's not pertinent to the administrative exemption, when DOL put out its draft regs, people were writing in saying, does that mean that surgeons who do manual work are non-exempt? And that would be like saying that someone who happens to put on a wetsuit and a tank and goes diving to, collect taxonomy samples as a marine biologist somehow changes from an exempt professional to a non-exempt person because they do manual work. Or some engineer slogging through a construction site all of the time because they happen to be running the construction oversight field office doesn't change their work from professional engineering work into non-exempt work. There's a certain level of common sense, if you will, that I think needs to be applied to the FLSA. You have to look at all of these things together. As a matter of fact, we had a question come in yesterday where I pointed out that the primary duty test includes all three of those major items. It's and, not or. I know this is a difficult concept to wrap your mind around, and it can take some time to learn. Professional exemption. Tell me in here how many people think we have a lot of people who will meet the professional exemption based on the last two lines. The end of the third to the last line and the last two lines. I don't think we have too many artists working for the government, and an illustrator is not an artist. I don't think we have people doing government work. Now, maybe they're doing it at night, at home, writing a novel that they hope will win the Pulitzer. And I don't think that we have too many people who would get the cinematography awards out in Hollywood doing work, or highly complex personalized portraiture. I'm not denigrating or looking down at anything that feds do, but most of the work in that area, like technical writer-editor work, writer-editor work, that is not the creative work that would be subject to the professional exemption. But we've got plenty of engineers, we got plenty of accountants, we got plenty of doctors, dentists, lawyers, teachers. Think of this, if you will, and once again I will date myself. If you go back to what you learned about medieval history in high school, you had the medieval professions, the law, clergy, medicine. And the Congress, in its infinite wisdom, as well as DOL, have really built on what were the traditional professions in creating the professional exemptions. And professions are added from time to time. I believe nursing became officially a profession for FLSA purposes back around 1970, 1971. Medical technologists. And take a look at the listing of professions. Notice the specific requirements for the what I call the legal learned profession exemption. I've gotten calls from agencies. Well, we have this attorney, aren't they exempt? And I say, if they're doing attorney work, yeah. Well, they're an attorney. Shouldn't they be exempt? Only if they're doing attorney work and they're admitted to the bar. So, just let's be careful about that. And if you go into DOL's website, even though we are certainly not bound by and we're not covered by the letters that they issue, the advisories that they issue, you will find a discussion of certain occupations there that I think will help you better understand how stringently the professional exemption has to be applied. Now, something tells me we're about an hour into this, so I think it would be wise to take about a 10-minute break, and then we can pick it up again. Okay, time to start again with everything you ever wanted to know about the FLSA. The other learned professions, now that we're leaving medieval history and coming to the present, include such things as the practice of medicine, accounting, engineering, architecture, teaching. And there's certain specific information in the teaching exemption people need to be aware of in terms of an institution of education, so on and so forth, which we will probably need to address sometime in the future in our regulations in more detail. Medical technologists, nurses. We decline to include certain recognized professions in the DOL regs. We didn't bring them into the federal regs because we didn't think there was a need to. I don't think that the federal government has too many professional trainers. And there are a few others out there. And also just be aware that just because something is a profession for purposes of the FLSA doesn't make it professional for purposes of classification and staffing in the federal HR system. Like dental hygienists, I believe, are professionals under the DOL regs. Last time I looked, they are in a single grade interval occupation in federal service. And we got comments on those when we put out our draft regs, and that gave us once again an opportunity to once again emphasize classification is not FLSA, and FLSA is not position classification. We actually went through this before, but there's another thing that we get into that can be extremely dicey, and that is the computer employees. And before anyone asks me why are we using such outmoded terminology, it's because computer appears in the statute. Now, we may like to edit and bring things up to date, but until Congress and the President change the statute and substitute information technology for computer, we will use computer. One of the points here is that there are two exemptions for computer employees. One of them is professional, one is administrative. Remember how I spoke about the administrative exemption probably being the most difficult to apply, the most contentious, and certainly the one that has been litigated the most. You will find that the computer exemption under 13A17 of the Act, that professional, does not require that you look at where that person is situated in the hierarchy and structure of the enterprise, because professional is not an extension of management per se. So you may find that applying the criteria to highly complex IT work leads to an exemption if it meets the compensation per hour requirements of 13A17, that you're likely to get an exemption result as opposed to situations where you might not get an exemption result but end up as non-exempt under the administrative exemption for computer employees. Two different criteria. Remember, if it meets one but not the other, it's still exempt. And let's talk for a minute how you might approach that in the federal sector. Getting you into the network after you've been knocked off, giving you a password, various and sundry other things like that are not IT work or computer work covered under the exemption. You need to make sure that you are not confusing computer technician type work with real IT work. So you'll find a lot of support work done by IT types is not computer work subject to the exemptions in the Act. Now, remember the concept of the FLSA is you analyze and you determine the primary duty. Well, we recognize that there may be periods of time when your primary duty changes. And that's why we've had the temporary duty work discussion in the regulations where, and let me give you an example. Hurricane Katrina or whatever comes blowing through. You mobilize a whole bunch of people, including professional engineers, who spend the next 6 months doing construction estimates that would be done by a construction rep or an engineering tech that do not involve the application of professional engineering knowledge, don't require it. For that period of time, so long as it meets the 30-day test, you got that engineer, if they're working overtime, earning FLSA overtime, not Title V overtime. Which I always say raises the question of do you really need to send a GS-12 or 13 engineer to do GS-7 technician work? But if that's all you've got, and those are people you can mobilize quickly, and the work needs to be done to meet your mission, certainly that's reasonable. The other thing here is emergency work. And there has been confusion about that, and I think that there are certain agencies that routinely have to deal with these issues. The Army Corps of Engineers, FEMA. They're two classic examples of agencies that frequently have to mobilize large numbers of people to either do temporary work or literally, during the crisis, emergency work. Remember, temporary work, 30-day test. Emergency work, it's for the period of the threat, which should be relatively short. I've had people say, well, you know, we were down there and it, you know, the hurricane was an emergency. Well, the emergency ends when the period of the threat ends. That means that when you've started to, you know, you've evacuated, so on and so forth, and when things are finally settling down, literally after the crisis, it changes back from emergency work to a non-emergency work situation. Emergency work does not go on forever. In other words, recovery from Katrina is not all emergency work. But that also is up to the agency. Now, the foreign exemption is very important to agencies that routinely have people traveling outside of the continental United States or the other enumerated possessions and territories that we list in the CFR that are considered to be non-exempt areas. The FLSA was passed and intended to only apply to the United States and its possessions. It is not applicable in India, Pakistan, London, Nigeria, wherever. And that means that if for any, if any time during a work week you are still in the United States or a possession and then travel, the foreign exemption doesn't pertain to you. But for any work week where all hours in the work week are not in one of those, FLSA will call it covered geographic locations, you lose. If you were if you do FLSA non-exempt work, you lose FLSA overtime coverage. So I'll give you an example. Someone who's in a GS position working in our embassy in London, week by week by week by week, doing clerical work, the foreign exemption applies. They don't get FLSA overtime. They get Title V overtime. And remember that Title V overtime has a cap. Availability pay is a statutory exemption. Anyone who has an organization filled with criminal investigators who are held to the requirement of being available, and who regularly do, availability pay applies. Now, even though the FLSA overtime exemption, FLSA overtime doesn't apply, also remember availability pay is basically a 25% bump in salary that applies for retirement purposes. And I think that went into effect around 93 or 94. And you're going to ask me what COPRA is, and I don't remember the acronyms, the translation. but it's the customs and type work that I was talking about before, where there's, once again, statutory overtime of a different type under 19 U.S.C. 267A or B. Now let me clarify that. There are certain hours that can be counted as overtime hours for purposes of COPRA. But if you're also, as a question in here before, raised the issue of what's called suffer and permit, if you perform work that would be covered by the FLSA but not covered by COPRA, those hours that are not covered by COPRA would be subject to the FLSA. So you could have two different forms of overtime applicable to people covered under COPRA depending on work control and assignments. But you're going to find that virtually exclusively in DHS. Now, to take you through some of the changes in the regulations, the reason why we used to do the old regulations the way we did and not have a salary test was that the salaries were so low prior to 2004 because they hadn't been changed in about 30 years. You know, we had no requirement for it. But what happened was we revised it to reflect the 23,660 because we found that there were certain NAFI supervisory positions out there on pay plans that actually made less than the 23,660. And therefore, under the DOL regs, they would have been, even though they may have met the executive exemption, they didn't meet the salary test. We figured that this exemption issue would disappear relatively quickly, and we think it probably has. This was sort of a transitional requirement. But because the pay per week threshold had risen, we needed to do this to make sure that we did not disadvantage any employee. So in other words, someone who would have met the executive exemption but was paid, let's say, $22,000 in a NAFI position and met the executive exemption criteria once again, would be construed non-exempt because they fell below the 23,660 threshold. Prior to the DOL 2004 regs, they had regulations in place, as did we, that for certain positions, you had to spend 80% or more of your time on executive duties. Well, DOL eliminated that, and we did because of a number of court decisions. And let me put this in a context. When we think of the FLSA, we think of the federal government situation. But remember, the FLSA in the private sector goes from engineering firms with support staff all the way down to Burger King, Dairy Queen, and McDonald's. So what you've got out there is a situation where you can have the manager of a McDonald's or a Burger King, and as a matter of fact, there was a Burger King case and a Dairy Queen case, where the manager was flipping burgers, if you will, like about 85–90% of the time. But that didn't take away from the fact that the primary duty of that position was literally to oversee the operations for that shift or whatever. And even though they were performing side by side and doing lots of non-exempt work, the primary purpose of that position was to manage. Make sure that whoever owned that franchise got the money. Hired, fired, so on and so forth. So the court found that Well, it's nice that DOL usually says 50% or more of the time, but that's not really a requirement. You have to look at what the purpose of the job is, the primary duty test. We went over the administrative exemption changes, and I hope that you read them to gain a better understanding of how we look at administrative work. We went into greater detail, as we went over before, to clarify the exemptions, particularly for the creative professions, which we really hadn't addressed before. And we also hadn't addressed before the fact that there are certain occupations, including law, medicine, and teaching, where there's no salary test. There's no minimum salary. We also transferred additional information that had been in our policy folders in the past that had been issued under a system that no longer exists. So we wanted to explain how you deal with first responders. This is not important to the average agency in a federal city, but it is important to a large portion of the federal government that has, for example, police departments and fire departments like you would have in a military installation. There may have been some confusion, and we hope that we've allayed that in application of 7K of the Act to fire departments, because there are certain positions. It's really structural firefighting that is intended to be covered under 7K. They have a whole different scheme of hours of work in a work period. There's also another whole block of firefighting work in the federal government called wildland firefighting. They're not covered under 7K. So you need to be very careful if you're dealing with firefighting. And law enforcement first responder work also has a different overtime threshold than regular the regular 40-hour, and law enforcement for FLSA purposes is separate and distinct from law enforcement retirement. So just like you can't confuse the verbiage of classification in FLSA, you can't confuse FLSA for law enforcement with FLSA with retirement. So those are a couple of very, very important points. They mean a lot to a lot of agencies out there, like Bureau of Land Management, Bureau of Reclamation, Forest Service, other components of the Department of the Interior, like Park Service, and it can be very, very significant in terms of getting the person's pay to be right. We actually was contacted, the second bullet, we were contacted by one of those land management agencies, and they were very concerned that they had what are called, they're really reciprocal agreements with state and local government, so that they provide firefighting services to each other. It's mutual aid. And some of these states allowed people under the age of 18 to actually be on the fire line. And the states basically said, you're in a mutual aid agreement with us, and these organizations, this agency asked us to examine this issue, because even though these people obviously wouldn't be federal employees for FLSA purposes, if our regulations dealt with this and prohibited people under the age of 18 from being in a frontline firefighting position, they could point that out to their mutual aid partners and say, yes, we will accept anyone other than people on your team who are under the age of 18. And DOL, I believe, is actually studying this right now, but we put it out to give these agencies more flexibility in dealing with their mutual aid partners to not expose kids who are maybe 16 or 17 years old to dangerous situations. We also clarified certain aspects of the FLSA claims and compliance responsibilities. For example, we added a period of time for reopening and reconsideration. There had been no cutoff time in the previous regs. In other words, an attempt to clarify what the requirements were and bring them into line with normal appellate practices that we have in other programs. So, what do you do in making an FLSA determination? Essentially something very similar to what you would do in classifying a job, because all of it depends on the quality of the fact-finding that you conduct. There's no reliance on position title. You can't just say, oh, someone is our IT officer, if you really don't have an IT program but are essentially buying those services from a contractor and your IT officer is essentially doing technician work. He's our human resources director. In some organizations, human resources is really contracted out, and what you've got is essentially a technician. So you can't rely on titles, just like you can't rely on the PD. Ultimately, you have to rely on the actual duties. You need to apply the primary duty test for whatever criteria may be pertinent and the additional criteria, and make a determination as to whether the person is performing exempt or non-exempt work. This question has come up time and time again in terms of what are our responsibilities. You know, if you've classified a position 15 years ago and you've had multiple people migrate through it, I think it would be good management practice to review the FLSA designation periodically as well. So if you have a performance discussion every year and you're looking at the accuracy of the PD every year, that might be a good time to revisit the entire issue of what are the duties for FLSA purposes. Are there any significant change to give the HR office, from the point of view of the employee and the supervisor, a heads up as to whether they really need to come and make a visit and go over the work to make sure that the coverage determination is or is not appropriate. Because remember, there's a lot of information out there. There are a lot of lawsuits out there. And you need to be aware of case law and of internet information like our decisions that we have up on the web, that once we get additional cases 508 compliant, we'll have new cousins to provide additional guidance. The other thing too, remember that OPM's interpretation of the statute has evolved over time. And therefore, it would behoove you, in my estimation, to pay more attention to the more recent decisions than some of the older ones. We're not going to pull them because of FOIA purposes, but you will find probably in the next year or two, you may find a couple of decisions that have been rethought and a new decision issued and the old one replaced. And as a matter of fact, we had that in one case. And that case hopefully will be posted within a reasonable period of time. It's one that was issued that deals with general investigation, where we had applied the administrative exemption and held the work to be administratively exempt probably about 15 years ago. And in a recent case, the whole point was that even though these general investigators did demanding work, they had no discretion and independent judgment on matters of significance because they made no recommendations. They were fact finders. They needed to develop the case, but the information was then presented to the security officer who made the clearance determinations or the HR people who made the suitability determinations. There were no recommendations. The only thing that they had discretion and independent judgment over is how to perform their own work. And that is not adequate for meeting the administrative exemption. So why is FLSA important? Because, let's say, the support person in your office is coming in early and leaving late and working through lunch because they're a dedicated employee. And somewhere along, and you knew or should have known because they're literally sitting outside your door and you see them eating a sandwich while answering the phone, and they decide that they don't like the way they've been treated, and they decide to file a claim for overtime under the concept of suffer and permit, I sure you hope you have extra money to pay them, back pay and interest. Or if it gets to court, liquidated damages, which they don't get interest, they get double what they should have gotten. And if they prove that that the violation was willful, instead of going back 2 years, you might have to pay 3 years worth of money. And you say, well, how do I deal with someone like that? Well, I'll tell you a story of a division head I knew who had a secretary who was doing that and told them not to do it anymore, working through lunch. And the third time came out and said, look, I really appreciate how dedicated you are. You're a great employee. I've told you we can't pay you and you can't work. And if you continue to, I'm going to have to take adverse action because we don't have the money to pay you. And I believe that person stopped working through lunch. I think work planning speaks for itself in terms of travel time for FLSA, what the costs are when you travel during corresponding hours on a non-work day. It's money for FLSA. Hours of travel that count as work under the FLSA are more generous than those under Title V. And that means money. And that's why a lot of places have started to adopt, you fly out or go there on Monday, you come back on Friday, around the same time as the end of your workday, if you will, because we're not going to pay overtime. If you can't do it, management just needs to be aware. It needs to have the money. Just talked about this. There was a question at the break about time spent in training. Remember, restrictions under Title V for pay, for overtime or premium pay under training are not the same as the restrictions in the FLSA. Once again, the FLSA is more generous. And you also have issues, certainly not typically in an environment like this, but preparatory and concluding activities frequently in a blue-collar environment where you have to make a determination as to whether those are, that preparatory and concluding time is or is not integral to the work, and if it is integral, then it's compensable. Another thing in here that is extremely important in the management of the FLSA, you can't go up to an FLSA non-exempt employee and say, I really would, we do have work to do for, that would produce overtime, but I don't have the money to pay you overtime, but I can give you comp time. No. No. It's at the employee's request, and that kind of statement could be construed as coercive, and it will get you into deep trouble. Also remember that if you rack up comp time and it's not cashed in and you leave the agency, if it's FLSA non-exempt comp time, not Title V comp time, remember we're talking about FLSA, you have to liquidate that at time and a half, albeit at the rate when it was earned. So there's no coercion when it comes to comp time. But we've actually talked about this in terms of the impact. We, in our administrative process, derive our authority to order a make-whole remedy under the Back Pay Act, which provides for back pay and interest. Our interpretation of the Act is that liquidated damages are under the control of a court of law or some other tribunal that has the authority under the FLSA to order liquidated damages. We're not a court of law. We can't order liquidated damages. So an administrative claim process provides for back pay and interest. Willful violation. Not all violations of the Act are willful. I don't know about you, but when I do something dumb or stupid, it's typically not willful. I find it rather embarrassing. But I still do dumb and stupid things. Willful means basically that you know what you're doing is wrong. And once again, it's an Employee Protection Act, so there's a penalty for companies or other entities who knowingly violate the Act. There are overhead costs to the FLSA program, too. If you're dealing with us, you got to produce an administrative report, and sometimes that requires quite a bit of work. So that's basically money out of the pocket of the agency because it takes staff time. Court suit, I think it speaks for itself. And the other thing, too, is unless your agency has been delegated representational authority, which very few have, you're going to have a Department of Justice attorney involved in the process, too. And that's quite a bit of money when you look at salaries. Negotiated grievance procedure. I believe we went over this before with Carter v. Gibbs and Mudge v. U.S. But the whole point now is we reject a lot of claim requests because we're dealing with a highly unionized workforce in the federal sector. I believe the bargaining unit status code is block 37 on the standard form 50. I tell people if that's anything other than 4 7s or 4 8s in a row, if there's another number there, you're in a bargaining unit position and you need to take a look at your contract if there's a contract. Sometimes there are bargaining units that do not have contracts, and that means they can come to OPM. We will have jurisdiction. But most contracts are silent on FLSA. And if they're silent, then they're to be construed under the court's decisions as automatically including FLSA disputes. We actually have one union that have one or two unions that have specifically excluded FLSA matters from the negotiated grievance procedure, and we have and are actually in the process of processing some claims from them now. So you need to make a jurisdictional determination, or we do in the claims world. That's the first thing you do. Now, your last chance for questions before we wrap it up. Well, hold on. We need to get a mic over there.
You've mentioned Title V a few times.
Mm-hmm.
When does Title V kick in and FLSA turn off?
If you're FLSA non-exempt, you apply the FLSA rules, because the hours of work for Title V overtime premium pay purposes have already been included in the FLSA regs. If you're a Title V employee, as we all are, and you're exempt, then the Title V premium pay rules of, I guess it's subchapter 55, apply. So, for example, you and I, who are doing exempt work, our entitlement to overtime flows from Title V premium pay rules, not the FLSA. And we typically will be capped because of the level of work we do and the hourly rate that we receive. We're going to get straight time. We used to get less than straight time until not that many years ago. So, FLSA overtime is, for non-exempt people, a better deal than Title V overtime. Now, there are other questions that have come in?
Just questions about how we're going to put it on the website.
We're going to try to, we will put this in post-production, and we are looking at putting it up on the website. But it won't be available for quite a while. And the other thing that we're looking at potentially might be discs. But once again, that is an open question right now, and certainly I will get back to you when I can, when I have more information. Anything else? All right, I want to thank everyone for coming here. It is a rather demanding subject, rather complex. It's not easy to master, and I can tell you I've been working at this for more than 20 years, and I still haven't gotten it all down. So, and it's also an area, subject matter, that is constantly evolving because of the court cases that flow through the system. So thank you very much, and enjoy the rest of your day.